We, the minority, have a preliminary objection to the vetting of 3 Supreme Court nominees today. Our objection, which I would here put across, are as follows. That, Chairman, today this committee takes a single further step towards the vetting of 3 nominees of appointment as Supreme Court justices. The minority would want to put on record a formal preliminary objection to the manner and timetable within which the vetting is proposed to be conducted. This is not an objection to the principle of vetting, neither is it an objection to the nominees as individuals. It is an objection grounded in the 1992 Constitution and the Standing Orders of Parliament to a process that, as currently proposed, cannot lawfully and safely be completed within 3 days remaining in this recalled sitting. We ask that this objection be resolved before this committee to proceed further, and that it appear on the record of these proceedings, regardless of how it is resolved. We advance 9 grounds. Each stands independently. Together, they are in our respectful submission conclusive. Ground 1, that there is no vacancy and therefore no exigency capable of justifying a compressed timetable. Chairman, the Supreme Court of Ghana presently sits with its full complement of justices. No seat on the bench is vacant. The 3 persons before this committee are nominated to add to the existing membership of the court, not to fill any gap left by death, retirement, or removal. This matters because the entire justification offered for compressing the ordinary vetting timetable is urgency. Urgency requires an urgent state of affairs. Where no vacancy exists, no functional agency exists. The committee is respectfully urged to require the majority to identify precisely and on record what harm befalls the state, the judiciary, or any litigant if these 3 additional appointments are vetted with the same care that would ordinarily attend any Supreme Court nomination. We submit that no such harm can be shown because none exists. Ground 2, Order 21711 has been misapplied. But even so, Chairman, before I go into Ground 2, we submit that since 1992, all Supreme Court nominees have gone through the regular period of notice where this committee advertises in the dailies for 2 weeks. It cannot be that just Monday, when Mr. Speaker announced the nomination as received from the President, Tuesday, Wednesday, and Thursday, Parliament is supposed to vet. It is not our position that we are against any of nominees. Neither are we saying that the President doesn't have the constitutional mandate to nominate for Supreme Court. What we are saying is that your party in opposition, and I refer to the verbatim report of 2024 July, Mr. Chairman, the transcript of appointment committee proceedings, 30th July 2024, and I use this transcript to support my Ground 2. This is what was said by Honorable Mahama Ayariga, Member of Parliament for Boku Central, then in opposition. Quote, we discussed this matter and said we don't want to embarrass these judges. It's a new appointment committee. Notice was served to the nominees to come without us having had a meeting. No meeting. Notice was served to the public to submit memos, and there was no meeting. Then yesterday we met, we said, quote, what is the rush? End quote. We have a lot of time. So let's take our time and not embarrass these judges. Let's do a decent job. We ask for documents. We ask for the writings and publications of one of the nominees. Then the other, who is the Court of Appeal judge, we ask for her judgment. You know how we always do it, so that we can study and do a decent job. And they wanted to even fix a date. Then the majority chief whip advised the two leaders to go and confer on the date. Chair, end quote. He goes further. We had these discussions nicely, and then we all dispersed yesterday, only to see during midnight WhatsApp exchanges that were being summoned as a committee to come and vet this book. Because of that, some didn't even go through their series. Now let me go to Honorable Ama Kofi-Boa, who was a deputy minority leader and a member of the committee. This is what he had to say. Quote, I was saying that first of all, why do we have a media here? The point has been made that appointment committee met. We discussed these matters. We all agree that these appointments are important. These are lifetime appointments. And once they sit in the Supreme Court, there is no opportunity for any Ghanaian to try to revoke the appointment. These nominees are going to replace Supreme Court judges that are not going on retirement, some of them till November. So it was clear that we have time to make sure that, as outstanding practice of this House, we published this nomination by the President in National Daily and get memoranda from the public so that we can totally, the people of Ghana must be part of this process. It's a serious process. We all agreed. I mean, let the point be made. Nobody has anything against, but we must do the right thing. End quote. This is Honorable Ama Kofi-Boa, Deputy Minority Leader, who is now a Minister of State. Now let me go to my respected colleague, who is now the Finance Minister. He was the Minority Leader, Dr. Cassiel Ato-Forson. This is what he had to say as Minority Leader then. Quote, then let me make this comment. Honorable Leader, he was referring to the chair who is seated to my left, Honorable Patricia PJ. She was the Deputy Majority Leader and the acting chair of the committee. Yesterday, I said something, and today I'll refer to you as my former friend because I'm honestly appalled. This is Atu speaking. I'm appalled. You have broken the trust of the NDC Minority Caucus. You have committed a number of sins. I will tell you the sins that you have committed. Your first sin, you unilaterally wrote a letter to the nominees inviting them for vetting without the input of the appointment committee. Your sin number two, you wrote to the nominees setting Wednesday 31st after informing them that we are Wednesday 31st without our input. Then number three, after we met as committee, your third sin, after we met as committee and agreed that we'll do this vetting before we are recalled, so that during the recall, you will take them unilaterally again and again. No, I'm enumerating all the sins that she has committed. And then you inform them that now you have shifted the goalpost from 31st. Then we even agreed to Tuesday, and going forward, you hold it and submit the report to the House. Madam, this is not Banana Republic. All these are words coming from Ato-Forson. This is the Republic of Ghana. This is the Black Star of Africa. This is Kwame Nkrumah's Republic of Ghana. Please don't destroy our democracy. This is coming from the NDC. At the minimum, you have to give us the opportunity to study the nominees, and the people of Ghana must see us that we are doing our work. We cannot joke with this democracy. These are some of the things that we do, and the democracy elsewhere, they lose them. We will protect this democracy at all costs. You are putting somebody into constitutional office until the age of 70. All what we are asking is that advertise for a minimum of 14 days invite memoranda. So far, you have advertised for 4 days. Even the advert, you didn't tell us you were advertising for this. Advertise for 14 days. Give us opportunity to review the CVs. Today, you have called a meeting. Me, today, I have not even read anything. I will end it here. Chairman, to reiterate ground 2 of our submission, these are the words of your party in opposition. You insisted that Supreme Court nominees should at least have that 14 days minimum notice in the dailies. You told us that back in the day, on that fateful day, what you did was to stop the vetting. We are not going to be physical. We are going to be decent and put across our case to the nation. My colleague here who was chairing the committee was heckled. We reasoned with you. I was the majority leader. And I called Dr. Atuforsen aside, pleaded with him, much as I tried. He said no. And on behalf of the government, I yielded to the prayer of the minority. So we called off the vetting. We apologized to the nominees. And we re-advertised for the 14 days before we finally did the vetting. So what has changed? You are saying that we must protect the democracy. We yielded to you because common sense required that we had to listen to you and not to insist that we are in government. We stopped. You said there must be 14 days. These were the words of the minority leader speaking for and on behalf of the NDC. These nominations came to the House on Monday. Referral was made to the committee on Monday. We had Tuesday. We had yesterday. And today we are to do vetting. We have Supreme Court judges and the respected Chief Justice right here. In all fairness, would they themselves feel right that Parliament is subjecting itself to these? Are we here to embarrass the nominees or carry a certain conduct and back with the political narrative? My colleagues in majority, no. Let's reason together. Let's be seen as having a principled political stand. Let's be seen as acting consistent with our political views. We yielded to you. We didn't allow ego to take over our conscience. So we yielded and asked the nominees to go back home. And at the right time, after advert, we did it. So if you want to follow that precedent, please suspend today's sitting. And let's properly put out the advert as you requested back then when you were in opposition. And let's allow 14 days. After all, the court is on vacation. 14 days, we can come back and do the work, receive memoranda, get our report ready even before Parliament resumes in October. Early enough for before the new legal year. We cannot continue to do this. I'm done with ground 2. Now let me go to ground 3. Ground 3, Order 21711 has been misapplied. It is our contention that Order 21711 requires this committee to report to Parliament within 3 days after the conclusion of its proceedings. That is a clock triggered by conclusion, a fact within the committee's own determination, not a clock that runs from the date of the referral or that compels conclusion by any particular date. No provision of the standing orders convert Order 21711 into a general instruction that vetting itself must be completed within 3 days or within the life of any particular sitting. Order 2674, by contrast, allows a committee up to 3 months to report on a matter referred to it. We submit, therefore, as minority, that Order 21711 cannot, on any proper construction, be read to shorten that general period to 3 days for 3 simultaneous Supreme Court nominations. Our next ground, that the composition safeguards in Order 2172 and 3 cannot be honored on this timetable. Chairman, we submit that Order 2172 requires the chairperson, ranking member, and 2 other members of the relevant subject matter committee to join this committee for each nominee considered. For the 3 judicial nominees, that is the committee responsible for constitutional, legal, and parliamentary affairs. For the ministerial nominees, it is, in each case, the relevant sector committee, or the 2173 caps the resulting membership at 15. We therefore submit that properly reconstituting this committee 3 separate times for 3 distinct subject areas, whilst respecting the 15-member ceiling and the 1/3 quorum requirement in Order 2651, cannot be done with the rigor these orders contemplate inside 3 days without either breaching the cap, diluting the co-opted membership actual participation, or reducing what should be substantive scrutiny to a formality. Any of those 3 outcomes will render the resulting recommendation procedurally unsound. We further submit that the public participation safeguard in Order 21710 would be rendered nugatory or otious by your conduct of proceeding to vet these nominees today. And on that point, it's our submission that Order 21710 requires the publication of nominees' names in the newspapers of national circulation for the specific purpose of inviting memoranda and representation from the public. Chairman, I rely on Dr. Atufosin's verbatim submission of 30th July to support this submission without reiterating that point. It is the mechanism by which citizens, the bar, and civil society bring to this committee's attention anything material to a nominee's fitness for judicial office that this committee itself might not otherwise know. A publication made this week, followed by hearings this week, gives no realistic person outside this chamber an opportunity to research, prepare, and submit memoranda before this committee purport to conclude. We therefore submit that a safeguard, which as a matter of simple arithmetic cannot be used, is not a safeguard that has been complied with. It has been observed in form and defeats in substance. We argue further on a ground to the effect that no motion to suspend the standing orders has been moved. Chairman, on the floor, there was no such motion properly moved, argued, and resolved to the effect that any of our standing orders be suspended. What we know is that the majority, after we were done with business committee report meeting, claimed to have recalled the business committee to hold another meeting, whereupon they claim that they added the vetting of Supreme Court nominees this week, and that after the majority leader has presented his report, same was gavelled as having been adopted. Chair, never on the House floor have we had such a precedent where a business committee's report was used to override express provisions of our standing orders. The adoption of a business committee report and recommendation can never replace an express provision of our standing orders that require a motion to be properly moved. Chair, we further submit that it is only by motion, moved with the leave of the House, with reasons stated prior to suspension. No such motion has been moved in respect of Orders 2172, 3, 10, or 11, or of Orders 265, 266, or 2674 in connection with these 3 nominees. Every one of those orders therefore remain in full force today. We submit with respect that the committee or majority within it cannot achieve by mere scheduling what Order 3 requires to be achieved by motion, debate, or vote. To proceed as though these orders had been suspended without the House ever having suspended them is not an exercise of discretion. It is a disregard of rules that remain binding. We invite you, Mr. Chairman, to ensure that this committee is bound by Order 217 in its unamended and unsuspended form and to conduct these proceedings accordingly. Our next ground, the constitutional preconditions to nominations under Article 1442 have not been shown to be satisfied. Chairman, we submit that Article 1442 of the Constitution makes the President power to nominate an ordinary justice of the Supreme Court conditional upon the advice of the Judicial Council and consultation with the Council of State. These are not procedural niceties. They are conditions precedent to a valid nomination reaching this committee at all. We submit, therefore, that before this committee proceeds to question any of the three nominees on merit, it should require the Clerk of Parliament or the Attorney General to confirm on record that the advice of the Judicial Council was in fact obtained and that genuine consultation with the Council of State in fact took place in respect of each of the three nominations. A truncated timetable makes it materially harder for this committee to verify that these upstream constitutional conditions were actually met, rather than merely asserted. This committee ought not to vet nominees whose own constitutional foundation has not first been confirmed. Our next ground, we submit that this exercise of discretion by the majority required to compress this timetable offends Article 296 of the Constitution. Chairman, Article 296 provides that wherever discretionary power is vested in any person or authority, that power carries an implied duty to be fair and candid, and its exercise must not be arbitrary, capricious, but must accord with due process of law. The chairperson's power under Order 2663 to fix the date and hour for considering a referred matter and the business committee's scheduling of this committee's business generally are both discretionary powers within the meaning of that article. We submit, therefore, that a timetable driven solely by the desire of the majority to conclude before this record rises tomorrow, unsupported by any demonstrated exigency, given that no vacancy exists, is not an exercise of fair and candid discretion. It is discretion exercised to suit political convenience, and it is, on that basis, vulnerable to challenge as arbitrary within the meaning of Article 296 of the Constitution. Our ground 8. Chairman, the Speaker's own ruling on the nature of this recall fortifies our objection. And on this point, we submit that in his remarks opening this recall, the Right Honorable Speaker drew a distinction of direct relevance to this committee. He stated in terms that his determination to recall Parliament was not and must not be understood as a determination of merit of the matters placed before the House. He stated that the material before him at that stage was not conclusive and does not dictate what Parliament must decide. He stated that the responsibility to weigh these matters properly belong to the House itself. We submit, therefore, that this committee, exercising the House's delegated function under Order 217, is bound by precisely the same discipline the Speaker described. The admission of these nominees for consideration during this recall settles nothing about whether they are fit to be approved, still less about how quickly that question may responsibly be answered. A committee that treats the fact of the recall as itself an answer to the question of adequate scrutiny will be doing exactly what the Speaker cautioned this House against. And I must emphasize that this unfortunate situation is being advanced by the NDC majority. Now, our ground 9. The consequence of error here is uniquely severe and largely irreversible. Chairman, I submit on behalf of my colleagues that Article 146 of the Constitution protects a sitting judge from removal, save for stated misbehavior, incompetence, or infirmity, established only through an elaborate multi-stage process. Once appointed and sworn, a justice of the Supreme Court is for practical purposes in office for the remainder of a working career. Parliament's approval under Article 1442 is realistically the last substantive check this republic will ever exercise over that individual's fitness for judicial office. We therefore submit that a procedural shortcut, which might be tolerable for an appointment more easily corrected, is not tolerable here. The gravity and near permanence of office being filled is itself a reason, independent of every ground above, why this committee should decline to allow itself to be rushed. The majority must not use its super majority in terms of numbers to stampede this process. Democracy requires that they sit and reason with us and not muzzle its weight and powers and frustrate the views of the minority. Chair, for the above grounds as argued, these are the reliefs we seek from this honorable committee. The minority, led by me, pray this committee for the following. 1. Determine that orders 2172, 3, 10, and 11, as well as 265, 266, and 267, 4, be remain in full force. No motion to suspend any of them having been moved or carried under Order 3. 2, we further pray that this committee resolve to decline to conclude its consideration of the 3 Supreme Court nominations within the life of this recall sitting, and instead adjourn that consideration to allow proper compliance with Order 2172 and 10 of our rules. 3, we pray that require confirmation on the record from the Clerk to Parliament or the Attorney General that the preconditions in Article 1442 of the Constitution have been satisfied in respect of each nomination. 4, is our prayer that this committee resolve to proceed in the meantime an unfair and expedited timetable with the vetting of the 2 nominees, which we have done, on which no objection of any kind was ever raised by us because there is precedence of the House to support that. And finally, record this objection and the committee's final determination in the report of the committee, ultimately as it presents to the House under Order 215. Chairman, with all said, I conclude on behalf of my caucus that this our objection is not being raised to obstruct the work of this committee. Neither is same being raised to embarrass any of the nominees before us. As we have already said, they are men and a lady who have worked all their life in service of our nation and even the sub-region. The president has the power and mandate to nominate them. We are not opposed to that nomination, save that when it was Akufo-Addo's time and he brought 3 Supreme Court nominees, your side argued that it amounted to the packing of the court. So as we speak today, you have nominated 7, Parliament has passed them, and these 3 added to it make it 10. So what has changed? Where is your principle? Now, the numbers to the Supreme Court are far more than it would have been if Akufo-Addo's 3 additional nominees had been approved by Parliament. So where is your principle of the packing of the court? Where is your principle? You have none. We so submit. A committee that vests a justice of the Supreme Court in 3 days, in the absence of any actual vacancy, in the face of standing orders that remain fully in force and were never suspended, does not strengthen Parliament's constitutional role. Rather, it empties that role of its content. We ask that this objection be decided in our favor. The proceedings should not go further, and whatever the course this committee takes must know that it has gravity to Article 144, Article 146, and Article 296 of the Constitution, as well as Order 217 of our own standing orders. The people of Ghana demand it. This is not a partisan demand because we are MPP minority. This is a demand from the people of Ghana. This is a demand that democracy requires of us. And Chair, we submit respectfully that this committee be resolved, that all these concerns be taken into consideration. We suspend the hearing and do the advert and come back and do the vetting. Until then, we tell you that, Chair, don't use your numbers to stampede this sound submission. Thank you very much.